Good morning, everyone. Hi, Jen. Hi, Marissa.
Morning.
We still have some folks rolling in, so we'll give people a few more minutes here, but thanks for joining us this morning. We'll get kicked off here in a minute. For everybody that's on currently, just a few housekeeping rules. There is a Q&A box down below. So if you have any questions throughout today's presentation, make sure you put them in the Q&A box and we'll answer those towards the end of the hour. If there's any audio problems or anything like that, just put them in the chat and I'll try to triage those as they come. Otherwise, let's get going here. Go ahead and share my screen. All right, let's try to get this going here. All right, so good morning, everybody. Thanks for joining us this morning for our compliance webinar today called That's a Wrap, Why Plan Documents Matter, everybody's favorite compliance topic. I'm excited to introduce Jen Berman this morning. She is fantastic and we love her at Connor Insurance. She is the CEO and co-founder of MZQ Consulting, a benefits compliance and ACA reporting firm that specializes in ERISA, COBRA, HIPAA, IRS code, you name it, she does it. She is a leading employee benefits attorney and compliance consultant who has helped us tremendously at Connor as well as many of our customers. So we are excited to have her here to talk about compliance today, specifically on plan documents.
Thanks for having me.
Absolutely. If I can get So here's what we're going to cover today. So we are going to talk about ERISA, what it is, and who has the fiduciary responsibility under ERISA. We'll talk about plan documents, what plan documents are included, and what happens if you don't have some of these documents, as well as how do those documents differ from document carriers or the documents you get from a TPA, for example. And then ultimately we'll wrap it up with what is a wrap document and why it's important that you might have one and that you should where you can go and how we can help you get that in place. So with that, we'll turn it over to you, Jen.
All right, so what is ERISA, first of all? So let's just start there. So ERISA is the Employee Retirement Income Security Act of 1974. All right. See, was that a test to see if I could still do it on my own, Ricky? Yeah. See,
a little bit. I've got a little bit of delay here, so.
Oh, all right. I mean, we're just gonna see if I can do it myself. Absolutely. There needs to be, I give me flashbacks to those. Like, I think when I did my when I did it, like I'm sure I had a multiple choice test at some point that had that question. It's like, is it employee or employer? And do you know? Yeah. All right. Employee Retirement Income Security Act of 1974. So the law itself covers both retirement plans and health and welfare benefit plans. And we're here today, obviously, to talk about the health and welfare benefit plan piece of it. But essentially what it is it's a law that's designed to govern all employee benefit plans. So not just retirement plans. Although for many, many years, particularly at the beginning of ERISA's life, most of the enforcement activity and most of the conversation around ERISA really did focus around pension plans, retirement plans, things where you were dealing with other people's money, rather than thinking about other people's healthcare. And it's really only in the past couple of decades, maybe even decades since the ACA, that we've had a lot more conversation about the applicability to medical plans and the other associated welfare benefit plans. And ERISA itself is largely procedural. A lot of its provisions also overlap with provisions in the Internal Revenue Code, And it gets at a bunch of reporting requirements, there's penalties in it, and it's all really designed to set up this set of rules and regulations that are designed to give sort of the rules of the road for an employer providing these benefits. Fundamentally, getting back to this idea that we're going to protect employees, we're going to set up a scheme, a set of rules and regulations designed to make sure that when an employer is going to provide these benefits to employees, two things are going to happen. The employees are going to be protected. So Department of Labor's job is to make sure that employees are getting what's promised to them from their employers. And the IRS, which is making sure that when you're giving a tax advantage to somebody, because fundamentally medical benefits are tax preferred, those preferred benefits are being treated in a way that meets the IRS's goals and Congress's goals fundamentally in giving those preferred benefits away. So that's kind of what ERISA is designed to do. Okay. So for a benefit plan to be subject to ERISA, we have this general definition. So first of all, you have to have a plan, fund, or program that is established or maintained by an employer to provide specifically listed benefits through the purchase of insurance or otherwise. So it doesn't have to be through the purchase of insurance. There doesn't have to be an insured element to it. And we see that come up in self-funded benefit plans all the time. And stop loss insurance is actually not typically part of the ERISA benefit. We'll talk about that later. To participants and their beneficiaries. So we have a program, we have an employer, we're going to provide benefits, and those benefits are going to go to employees and their beneficiaries. Those are the four elements that we're looking at. Okay. And then we have a bunch of things that could happen. We could have employer-sponsored benefits that are not subject to ERISA. And this is going to matter sort of later on when we're trying to figure out what's going to go in our plan, what's not going to go in our plan. It matters sometimes for taxation purposes. But really, I think it's most important to know that these plans don't have the same protections that an ERISA covered plan does. So what are these voluntary benefit plans? Sometimes they're enhanced benefits. These are ones that are exempt from ERISA. And there's four rules that sort of get you into that category. And they are, first off, that there can't be an employer contribution. Participation in them needs to be voluntary. So that's why they used to be, in the old school, they were called voluntary plans, but now sometimes you'll hear them called enhanced plans or something like that. The employer can't endorse these plans, and that can sometimes cause some confusion. What does it mean to endorse them? And the employer can't get paid to provide them. So examples of these could be times that we'll see them. Sometimes there'll be a buy-up life insurance product might be a voluntary plan in certain circumstances. A pet insurance plan could be a voluntary benefit. There's all sorts of things that could be voluntary benefits. And then the question becomes, like, do we even want to treat them as voluntary benefits? Because is it a bad thing to be covered by ERISA? Is a question that comes up all the time. And the answer is not necessarily. So a lot of conversation happens around voluntary plans, and is this or isn't this voluntary, and do we need it to be voluntary or don't we need it to be voluntary? And I sometimes stop those conversations and say, so what? Why do we care? What does it mean to be a voluntary plan? It gets us out of ERISA, but what does it mean to be in ERISA? It means that we're affording employees certain protections. Is it a bad thing to be affording those protections to our employees? Is that something that we really care about? It means we're going to include them in our plan document. It means we're going to include them in a 5500 if we have to file that 5500. It means the plans that those benefits are going to be subject to certain claims and appeals procedures, which we of course need to make sure that that voluntary benefit carrier can provide. But so what? Is it going to really hurt us as the employer to do those things? So when we talk about voluntary benefits, is we're trying to determine what's covered by ERISA and the benefits that we are providing. before you get too deep into the is it or isn't voluntary conversation, another question to ask is, does it matter? And do we really care? Okay. So as we're setting the table, we do need to know what are we talking about? So once we know that we are dealing with an ERISA plan, what things does that mean? What does it mean that we're subject to ERISA? Well, first off, it means we have to have plan documents. That's why we're here today. This is the purpose of this webinar, is to really talk about that plan document requirement. And we will get into that in much more detail in just a couple of minutes. Next, it means we have to follow the ERISA claims and appeals procedures, and that sets out a whole detailed set of rules about how much time we have to process claims, what needs to be included in a denial, what needs to be included in an appeal, all of those things. There are reporting requirements. I mentioned the Form 5500 reporting requirement. It's probably the biggest. And there are certain disclosures that we have to make sure that we make to our participants. So those are the big things that ERISA requires us to do. So ERISA is all about process, procedure, making sure that we follow those processes and procedures every time. Okay. It also creates a fiduciary duty. So what is a fiduciary duty? What does that mean? Well, it means that you have a special duty as a plan sponsor beyond just kind of doing the right thing. You have to go above and beyond what you are as an employer, and you have to make sure that you are doing right by the employee. You have a higher standard of care to make sure that you are taking care of them. And ERISA sets out a roadmap for what a good plan fiduciary has to do. And I kind of like to set this down into 4 rules. So here are Jen's 4 rules of how to be a good fiduciary. They say them in different words in the statute, but this is my version. Number 1, you have to act exclusively in the best interest of individuals covered by your health plan. Now, this is after you've established the health plan. So when you establish the plan and you decide how much money they have to pay and stuff like that, you can do all of that. That's called a settler function technically, and you can do that however you want. But once you are administering that plan and you are no longer wearing your employer hat, now you are wearing your plan administrator hat, you have to act in the best interest of the people covered by your plan, exclusively. That is what you're doing. Rule number 1, act in the best interest of plan participants. All right, rule number 2, you are expected to understand your health plan and how it works, and then you have to act like you know how it works. So, understand your plan and act like it. Rule number 3, it is not your money. Take care of it wisely. Act like it's your money. Or act like it's your kid's money, or your daughter's money, or your neighbor's money. If you don't spend your money wisely, treat it with care. And rule number 4, the plan document is the contract. Follow it. But wait, what's a plan document? I need a contract? Huh. Fine, we should mention it. I guess we're going to have to talk about a plan document now, right? Huh. Did she set me up for that? Yeah, I guess she did. Right. So how are we going to follow in rule number 4 if we don't have a plan document? I guess we need a plan document, right? So our plan document is in fact the contract between the employer and the employee. That's how we know what you have to do to be a good fiduciary. And ERISA, in fact, requires that we have 2 documents. It says you have to have a plan document, and then you have to have a summary plan description that explains that plan document in a manner reasonably calculated to be understood by the average plan participant. And that idea comes from a world in which plan documents are so complicated that an average participant couldn't possibly understand the plan document. And there's a lot of debate between ERISA attorneys about whether or not you actually need 2 documents, or whether or not you could write the SPD in a way that you write the plan document in a way that you could just actually understand it, and that would fulfill the SPD requirement. I'm of the opinion that you probably could write a plan document simply enough that people could understand it. Other very good ERISA lawyers disagree with me. I just think maybe they're not able to write that simply. I don't know. I mean, reasonable minds can differ on this. The law definitely says you need both, and one needs to be written simpler than the other. But then you have 2 documents that could conflict with each other. So I'm kind of the opinion, just write one that's simple enough. But either way, you definitely need this document that explains things, and you have to have at least a version that people can understand. That's what we're getting at. You have to have a document that explains what's going on, and that becomes the agreement between the employer and the employee that explains this is what the plan provides. Okay. All right. So what goes on this document? What do we need to include in this document? Well, ERISA also is going to spell out a whole bunch of things that have to be included in the document. Those include specific rights of the plan participants, what benefits are available, who's eligible for those benefits, how those benefits are funded. Is there an insurance policy funding the benefits? Is the policy, is the benefit self-insured? Who is the named fiduciary? By the way, the fiduciary is either the employer or like a committee established by the employer every single time. The fiduciary is never like a carrier. That's the wrong answer. You can't cede that responsibility to a third party. You can establish a committee, but that's about as good as it gets. I always have clients who are like, can we just make it like insert insurance carrier's name here? And the answer to that one is no. How the plan can be amended and the procedures for allocating the plan responsibilities. So I didn't make up this list. This list comes straight out of the statute. Okay, so all of this is listed in ERISA. All of this has to be included in the plan document. All right, let's keep going. And then the SPD has to have, again, plan information identifying who's eligible when, a description of the plan benefits. So what actual benefits do you get? What could cause you to lose those benefits? The claims procedures, and then something called the Statement of Participants' ERISA Rights. That comes straight out of the regulations as well. I mean, it is set in the rules, like word for word, exactly what it has to say. All right. Then there are all of these health plan disclosures. They could make your head want to spin, and they are all required also. And some of these can be included in your plan documents, but others of them are in addition to your plan documents. And then there's all these questions about how we get them to you and whether electronic distribution is enough and all of these different things, but all of these are also required. So you have your summary of benefits and coverage. That's required out of the ACA. It is the 4-page, but really 8-page, but sometimes 10 pages or sometimes 12 pages document that is meant to be like the nutrition label on the side of your cereal box and describes your plan in ways that you're supposed to be able to compare it easily to other people's plans. And does follow a standardized format, and that it does basically follow a standardized format, specifically describing the benefits available under your plan. It's different than a summary of benefits that you might find in like a benefit enrollment guide, in that it does follow the specific formulated government formula for that. There are healthcare reform notices that also came out of ACA. There's a whole plethora of COBRA notices, including the general notice that somebody gets as soon as they enroll, as soon as they're eligible for a COBRA eligible plan. And then there are things that you get when you have a COBRA qualifying event. There are HIPAA special enrollment notices, women's health cancer rights notice. I'm not going to read you this entire slide. What you need to know is there's lots and lots of notices that are required. And we got to make sure that we're getting you all of those notices too. It's a lot, and it's a list that keeps on growing. And it all gets back to this fundamental principle of we've got to make sure that the participants and beneficiaries who are eligible for these plans know what their rights are. Somebody out there is thinking, Jen, they don't read these notices. I am fully aware of the fact that they don't read these notices. So then you're thinking, well, then why do I have to send them? And my response to you is, because I say so. And then your response is, who are you to say so? And my response is, okay, well, I only say so because the government told me to tell you so. So you don't actually have to believe me if you don't want to. I am only saying so because they told me to tell you so. So you really don't have to listen to me. But like, you know, hey, I'm just telling you what the federal government told me to tell you. So like, you don't have to listen to me, but neither do my kids, but I am smarter than them. So it's totally up to you. But listen, usually my 14-year-old comes back to me later and is like, hey, mommy, you were right. Totally up to you. Most of the time, though, they come back afterwards and we're like, oh, mom, really should have listened. All right. All right. All right, here's some other reasons. All right, as I mentioned, plan documents, specifically the SPDs, have to be written in a manner reasonably calculated to be understood by the average plan participant. Marissa wrote this easier. She said it has to be written in a manner easily understood. Has to be furnished at specific times to specific people. There is a penalty. It can be up to $110 per day per participant. I guess that's better than because I say so. It's true. There's some DOL enforcement activity in this area. There's lots of lawsuits where people sue for this money or talk about trying to assess this. And then SBCs are also required. Talked about already.
Hey, Jen, quick question.
Mhm.
When do these documents and disclosures need to be distributed or furnished to specific individuals?
Typically speaking upon when they're first eligible and then annually before open enrollment.
Thanks.
Mm-hmm. All right, what happens if I don't have plan documents? Please keep breathing, first of all, because you're not in like bad company. But there is a penalty. It's up to $110 per day per participant for this. If you aren't able to provide it within 30 days of the request. So those penalties are out there. They do get assessed sometimes. The 30-day scramble is an ugly situation. It's something to be avoided. I will also mention that it is not only a matter of the penalties and worrying about enforcement. The other time I see this come up and become a really big problem is in any sort of corporate transaction activity. So this is not just limited to, you know, oh, is this ever real? Does this ever really happen relative to government enforcement? It comes up in due diligence and deal activity all the time. And that's another real place where it becomes a problem for employers who haven't taken the steps to make sure that they have what they need. Failure to provide materials requested by the DOL. Marissa, really?
So that's the new amount. I did in fact check for 2023. You are up to that 184 per day, not to exceed the 1,846 per request. It is also, you know, inflation is real for the DOL too this year, guys. I don't know what's going on, but that is the current number.
All right, thanks for that. You're making us all feel warm and fuzzy inside.
So sorry.
This is Marissa. She's a compliance advisor here at MZQ. She does our inflation adjustment slides. We love her.
Yeah. Sorry, I had to have the bad news, but I thought better factually accurate and scary than not at all.
We really do. We appreciate her around here. All right. All right. Documents the carriers and TPAs produce. We'll move on from the scary part and just talk about how we fix these things. Because I know everybody's perfect here and nobody wants to know about how we fix it, right, Ricky?
Yep.
We're done. We're done. Everybody's got everything.
Nobody wants to fix it. It's fine.
Oh, okay. So we'll wrap it up now and give everybody. We're done.
Yeah. Might as well.
Okay.
We should maybe talk about this next piece. This one gets real confusing for some folks. So
all right, we'll keep going. We'll keep going. Oh, all right. We'll just keep going just in case anybody wants to know the rest of it. Okay. All right. So let's talk about what documents we are getting and what documents we aren't getting, and just theoretically, if we needed to do a little bit more, what that might look like. All right. So what documents are we getting? And then what pieces do we need to sort of complete the puzzle here? So as plan administrators, employers do get documents from their TPAs and their carriers. And in some cases, those TPAs may assume the responsibility for producing plan documents, but it's not always all of the pieces. So oftentimes what they produce are benefit booklets or coverage certificates that describe the benefits being provided under the plan. And usually they do produce something, but the plan sponsor, the employer, is ultimately responsible for to make sure that the final package is complete, right? So what the employer needs to ultimately do is make sure that we have the plan document, the SPD, the disclosures, all the pieces fit together. And then depending on who the carrier is, who the TPA is, where the third-party information is coming from, it might be closer to a fully complete puzzle, or there might just be really big puzzle pieces. Almost every vendor that is providing, claims administration services is providing pieces to this puzzle. It's just how big the pieces are and how complete the final picture is that we have to worry about. So that's what we're going to talk about here. Almost nobody is providing a complete picture. And that's for a few different reasons, and we'll get there. So if we can go on to the next slide. So what a wrap plan does, and I'm going to come back and talk about the pieces that we get from the vendor in a second. A wrap is short for the concept of a wrap around. So it's and what an employer can do and how these work is that an employer satisfies the ERISA SPD and really the plan document requirement and many of the other disclosure requirements by using one document around all of the pieces that they ultimately collect from not necessarily just their medical carriers or TPAs or whomever, but all of their different lines of health and welfare benefits. So they might get an evidence of coverage from an insurance carrier on a life insurance line, or a dental line or a vision line, or just a description of benefits, from a TPA for their medical. All these different pieces. Wrap plans are designed to go around whatever it is that they've collected, all the different pieces, and wrap them all together in a way that says, I don't care how complete the job that was done by my carrier, my TPA, it doesn't matter. I'm going to have this one overarching document that is designed to include all the things that ERISA says that I need. And it's going to have everything in it except the description of benefits. Because what the benefits are is something that really can only come from the vendor that is administering those benefits. And then depending on the vendor, some of these, TPAs in particular are superlative at the jobs they do. They have amazing compliance departments, and they've got documents that include every detail to a T that you would want to have in a document. But we want to be able to file a 5500 that includes not just that medical plan, but also 4 other lines of coverage that employer has. And we need a wrap plan to be able to put them all into one plan, capital P, for ERISA purposes. And that doesn't do that. Doesn't include the other lines of coverage. They still need a wrap plan. Some of what you might get is, teeny tiny, barely has the description of benefits in it. Doesn't have any of the other ERISA requirements. And we need the wrap plan document to make sure all of the ERISA requirements are hit. The use of a really good wrap plan gets you all of those things checked off. It allows you to make sure that you've got everything that you need covered all in one document, and that you've collected all of your puzzle pieces. And then you can take this overarching wraparound document and put them all in one place. and check all of those procedural documents. It is not going to define your benefits. The vendor's documents do that. And you absolutely need documents from every single vendor explaining that piece to them. It is going to define eligibility. It is going to define waiting periods. And it is going to make sure that all of the minimum legal requirements are met. And then everything else is going to sort of trickle down to the documents that are wrapped into that overarching plan. So what you end up with, if you think about it, in many ways, it's not like a single document, but almost picture like a binder, like a trapper keeper. And your wrap plan is like the cover document. And then all of your other documents that are produced by those vendors, be it a carrier in a fully insured environment or a TPA in a self-funded environment, are the exhibits to that master wrap plan document. And that's really how you satisfy ERISA using this wrap plan tool. Does that make sense? So the wrap plan document itself includes the summary of plan benefits, but how does it do that? It just says the plan benefits are, and then it lists all of the attachments. Cost of participant, it just says check the materials that came from your employer this year. Making benefit elections, it tells you you can make them. Changing, and it tells you that you can change them. And then it hits all of these requirements under ERISA, the same ones we talked about a few minutes ago. So it's just designed to check all of the ERISA boxes. Go to the next slide. And now I'm ready for questions. So the solution is actually pretty simple to what is a very, very complex problem, because you got a million puzzle pieces. So basically what we do is we collect them all, stick them in a box, we close the box, and we take a different document and we put some wrapping paper around the box. And we don't even bother to try to fit the pieces together.
We do have a couple questions. So, are plan documents necessary for employers who are not subject to ERISA?
So, legally speaking, there is not a requirement that non-ERISA plans, so that's church plans and governmental plans, have them. However, I recommend that they do. I recommend that they write out like that they don't necessarily have to comply with all of the terms of ERISA when they have them, so that they don't necessarily fall into, necessarily having to follow like the claims and appeals procedures and stuff like that. But sometimes you want to subject yourself to ERISA because ERISA has favorable terms for you, like the claims and appeals procedures and stuff like that can be good. So while they're legally not required, they set out a set of terms and conditions that can be useful because they tell you what you need. So yes, plan documents are not free and there's some work to be done. But if you don't have your contract that tells you how things are going to work and what the terms and conditions are in the relationship between the employer and the employee, you're kind of flying blind. So what does necessary mean? Are they legally required? No. Are they prudent? I think so.
Do documents have to be printed, or can a fiduciary file to be kept fully electronic?
It's a great question. So, a complex answer. Documents have to be provided to participants in a manner reasonably calculated to ensure actual receipt. That is the ERISA standard. There is a safe harbor under ERISA for electronic distribution that is very, very, very hard to meet, particularly if you have a workforce that doesn't use a computer as an integral part of their daily jobs. If you have a workforce and it's like a bank or a law firm, pretty easy. But if you have people who don't sit at a computer to do their job all day, up to and including like nurses who just have like a kiosk station, that doesn't work. it's hard to meet that safe harbor, because safe harbor was developed in like 2000. And from a technology perspective, that was like centuries ago. But I like to rely on that ERISA like the ERISA definition, which is reasonably calculated to ensure actual receipt. So what I recommend that my groups do is post their documents electronically in a way that doesn't require a username and password, but instead has like a alphanumeric code to get to. So it's still hard to get to. The username and password becomes an issue relative to participants and beneficiaries getting access, which is a long and complicated story, and then mail postcards to the home. And I think that process meets not the safe harbor, but the ERISA distribution standard. Printing is ridiculous because when these things are done, they are like 500 to 1,000 pages long. And that's just like, if I told you you had to print them, you would say, thanks, Jen, and smile, and then walk around and say, that woman's crazy, and not listen to me and never distribute them at all. So I don't want you to do that. So I have a middle ground solution.
Perfect. That answers another question. So a couple more. Does a wrap document get handed to the participant instead of all of the pieces?
Unfortunately, no, we got to give them all of the pieces to be complete, but we only have to print them if the participant asks to. So the other thing I forgot to say just now is when we give them the postcard or when we go with that electronic option, we do have to tell them they have a right to request a paper copy. And if they ask, then we do have to print all of these.
All right. So another question here, if having a document that is if the document has to be easily understandable, does that mean it needs to be made available in different languages?
In certain circumstances, it does. So it depends on the percentage of your population that speaks that foreign language. But yeah, if you have a significant portion of the population that is non-English speaking and speaks the same non-English language, it very well could need to be translated into that language.
Would that be just the wrap document portion or all of the pieces included? Right?
All of the pieces, because we need those other pieces to describe the benefit. So the wrap document portion is boring, doesn't have any of the good stuff, doesn't tell you where to go or if your broken leg is covered.
All right, another one here. This is related to, I believe, the 5500 reporting. And it asks why nonprofits and self-funded medical plans never provide any information when they fill out their form 5500.
So I can't speak to nonprofits, but I can tell you why self-funded medical plans typically don't fill out information when they fill out their 5500s. So 5500 Schedule A's are required to be filled out on fully insured lines, and Schedule C's are required to be filled out with respect to service providers to the plan that are receiving more than $5,000 in compensation. When you are dealing with a self-funded plan, those fees are being paid out of the general assets, and the general assets of the employer. The insured component of a self-funded plan is not actually insurance that is carried by the plan. It is insurance that is carried by the employer outside of the plan. So the plan itself doesn't carry insurance, and the service providers are typically providing services to the employer, not to the plan. And so there's really very little when you go into the 5500 instructions that needs to be reported, because most of the services and the insurance is actually held by the employer, not the plan itself. And that is why there's so little that needs to be reported.
I think one question that we get at Connor Insurance a lot related to this, and the wrap document piece relates to the 5,500, and how I've had numerous situations where we have to file and we ask, what's the plan number? And they say, oh, it's 501. And then you find out they have multiple plans and there is no wrap document. Maybe you could talk a little bit about the implications of that and why we really are encouraging, not just for the simplicity of, one document that's housing all of this, it's trapper keeper, so to speak, but kind of the other implications.
Absolutely. That's a great question. Thank you. The 5,500 reporting requirement does not just apply to medical. And we all sort of have this tendency to think about plans as being medical plans. It applies to all lines of ERISA coverage, and really all lines, unless there is an exception. And so in the health and welfare world, that includes medical, dental, vision, and ancillary lines. So life insurance, disability insurance, all of those are covered as well. If there is no wrap plan, that means that each and every line needs its own 5,500. And you could easily, as an employer, find yourself filing 5, 6, 7, 8 separate 5,500s. We've come into situations where employers easily have 7, 8, 9 5,500s that they need to file because they don't have a wrap plan. The only way, technically, that an employer is permitted to file a single 5,500 is if they have a single plan, capital P plan, for all of those different lines of coverage. The way to do that is to put a wrap plan document in place. That's what bundles all of those different lines of coverage into a single plan.
And how often should employers update their wrap document? Is there a certain time frame or a trigger?
Yeah, there is. So the reality is, and nobody's gonna like this, you gotta look at your wrap plan every year. And the reason, and we do this every year at MZQ because we maintain lots and lots and lots of employers' wrap plan documents, and our team reaches out annually after renewal on this to update them every year, because it is exceedingly rare that nothing has changed. It is quite common that somebody says, oh, nothing's changed. And then we send something that says, all right, these are all your benefits. And they're like, oh yeah, well, nothing changed except, yeah, we did do this one little thing with our dental. Like, that's something. So the one little thing with the dental, or the one little thing that we did, like we didn't do a carrier change, or we didn't do a major benefits overhaul, doesn't mean that nothing changed. And so it does need to be looked at every year. And it is so common that people get complacent about the wrap plan document because it's the paperwork and it's compliance, and compliance is boring and nobody likes Jen. I know. But this is the contract. And if the contract says that you're, offering DHMO option 2, and you're offering DHMO option 4, you're essentially in breach of your contract. Like, these things matter. And so you do have to look at it, even though nobody likes to do the paperwork.
Yeah, that's something that we really try to consult on every year as well, just because the smallest, even like an eligibility change, those have implications for your members that are ultimately the benefit of going back to why we have a plan and who we serve by having a plan. So if there's any other last minute questions people want to submit, any other closing thoughts, Jen, Marissa, otherwise.
I was going to say, we can definitely, Jen, you can speak to having documentation organized and proper and how it affects other portions of compliance, like these RxDC filings and things that we just saw, and how complicated it was for employers to then meet other compliance requirements that almost domino effect down, I would say.
Yeah, that's a great point, Marissa. Yeah, so I mean, so we just went through our XDC filings, and I mean, even the simplest things, I mean, so plan numbers came up a lot. What's your plan name? Would be, it is remarkable the number of employers who don't know the name of their plan because they've never named their plan because they have no plan document. So what is the name of your plan if you have no plan document? So we had to make one up for like hundreds upon hundreds of employers because they never did the exercise of creating a plan document, right? So, and all of these things do domino and become major issues for people. So it becomes readily apparent as our compliance environment is changing. So I think I alluded at the very beginning of our session to the fact that in the beginning of ERISA, the emphasis was on the pension plan world and the retirement plan world. And that the past decade, we've seen more and more in the health and welfare world. The past 2 or 3 years, we've seen the health plan world get a bigger and bigger spotlight since the CAA was passed. And the past year, I would say that we've seen an exponential increase the attention on health plan compliance. And I think that that's only going to continue to grow. And this is, I call plan document like ERISA good hygiene. This is like brushing and flossing your teeth. And so if you're not brushing and flossing your teeth, like your overall health is, you know, not going to be good. And as we're starting to see so much emphasis on health plan compliance, you know, this is just the basics, but the basics matter. They matter a lot.
Then I noticed there's a Q&A question about whether we can simplify required notices or whether they have to be kept the way they are when distributed, which I think also goes to some of those templates, I guess, template language that ERISA gives, if that.
Yeah. The federal notices can be simplified. They don't have to come out in the way that the DOL has put them out. We've rewritten all of ours. So like the ones that MZQ uses are not the format that the federal government puts them out in. Because I don't think the federal government's versions are very understandable. So I rewrote them myself. Don't tell. No, it's okay. It's perfectly fine. I just rewrote them.
We do have one other question. This is because you had mentioned earlier about church groups being not subject to ERISA. So this question is, what happens when a church group does decide to be subject to ERISA? Like in the case of if they want to offer COBRA, for example, how does that change for them?
They just start to subject themselves to ERISA.
And that means all of the requirements we mentioned earlier, they now have to, they cannot pick and choose what they want to.
When you're in, you're in.
Perfect. All right. Well, I think that wraps up our questions. If there's anything that anybody has any questions at the, you think of in the 2, 3, 4 a.m. in the morning because you're just mulling over all of this great compliance content you just heard, feel free to reach out to us at Connor Insurance. We can get you in touch with Jen and Marissa at MZQ. They are fantastic and can also help you with getting a wrap document if you need one. Basically, we will send this slide out as a follow-up for everybody that's attended today. So you have some of these checkpoints to make sure you've got all of these documents. And like I said, if you don't, please reach out to us. We'll get you where you need to go and make sure you're compliant moving forward, especially as we enter fourth quarter and think about how, most of your plans are probably renewing 1/1, so this is going to be top of mind. So thank you, Jen, Marissa, for joining today, and thank you everybody for sitting through 50 minutes of plan document conversation. It's been riveting.
Always. Thank you. Thank
Thank
you.
you so much. Have a great holiday, everybody.
Be well.